I'm really excited to present our next guest, Ed Alexander. Ed Alexander, he's got a background in engineering. He was a marketing manager, and he's been a lawyer for over 24 years now. But the cool part is he's only specialized in business law. And he literally wrote the book on it. He wrote 10 common and costly business-killing legal mistakes and how to avoid them. But today I brought him on to really tell us about 4 types of agreements that'll make or break your business. Because at the end of the day, that's what really matters, and that's what really drives it home. So, Ed, thank you so much for joining us today.
Thanks, Joel. I'm looking forward to it.
So, I brought up kind of the 4 types of agreements. Can you take me through kind of what are the 4 types of agreements?
Well, if you look at it, they match kind of the relationships that you have in any business, right? So it's an agreement with your customers, it's an agreement with your landlord, it's an agreement with your partner, and ultimately it's an agreement with your employees, right? So if you think about all those types of relationships that make a business work.
Yeah.
So you definitely want to have really good provisions in your lease with your landlord so that if you sell the business, you can actually transfer the business. Sometimes it holds things up. There are some gotchas in those types of leases where they change the rental rate at the time that you sell, and obviously that's a negative because somehow it never goes down. It always goes down. You want to make sure you have agreements with your partners because surprisingly enough, people will act in rather irrational ways when it comes to getting mad with their partners. And so you want to make sure first that you're not in business with your partner's spouse or children, right? So if the partner dies, we don't want the husband showing up trying to run the business, right? Or God forbid, the children. And if you decide, and most people do this at some point, they say, hey, I'm ready to do something else with my life. And so they move on. How do we divide that business? We want a mechanism to make sure that occurs. And then when it comes to customers, invariably you're going to have some disputes with your customers, right? And so if you're selling to somebody in California or New York and you're located in Florida, the laws of those states are going to vary substantially. You want to make sure that any fight that you get into is on the laws of Florida, or in that case, or the state where you're at.
Yeah.
And that if there's a court battle, that court battle occurs in your location. And I'm kind of giving you the highlights. Obviously, there's pretty significant detail that has to go into these things.
No, of course.
Yeah. And then ultimately with your employees, what you don't want to do is pay somebody to go off and be your competitor, right? So pay them to go out and sell and build your business, and then they take your customer list and walk out the door.
Yeah. And as far as, just to go in a little bit more deep on that, what kind of contracts should these be? And do you need an attorney to draw that up? How ironclad should these agreements be? Because that back and forth could always take so long.
Well, so if we look at the partnership agreement in particular, because that, that's almost one, that and the customer are so important.
It's a marriage.
Yeah, that's exactly right. And it's an economic marriage. There's no emotion to it whatsoever, or maybe there's negative emotion. I don't know. But working through those steps should be a logical process. What we do is I have a 2-page checklist, and we walk everybody through that. We find that when they come in and they have a conversation around a table, we can, as the conversation is going on, we can offer dynamic advice. So if they say, hey, we're thinking about going off in direction A, we could say, well, the benefits of direction A are this, but the negatives are this. Here's another option B, that type of thing.
Right. That's important, and really to kind of see the road bump before you get to it. Yeah.
And the thing with a lawyer versus a non-lawyer, right, is that when a lawyer drafts a document, it needs to be ironclad, right? And usually you don't get that with a lay person. A lot of times I'll get contracts when lay people draft them, and they'll define the same provision 2 or 3 times, and there's all these ambiguities and things missing and whatnot. What I kind of analogize it to is I'm sure everybody's seen Fixer Upper on HGTV, right? And I always tell people, hey, you know what? I can go out and buy the same power tools and the same pieces of furniture and the same paint that JoJo and Chip use, right? But somehow my creation doesn't come out the way JoJo and Chip's does, right? And it's they've been doing it for years and they know what to do, and I don't, right? But I do in the law, so.
I think it's a perfect segue. One of the things that we get asked a lot, should I have an NDA and who should sign it? A lot of the companies that have products, they're going to be speaking to distributors, they're going to be speaking to retailers. Should they have an NDA on hand, and who should they ask to sign that?
So an NDA is, and I'll tell you, that's the most valuable piece of intellectual property you have are your trade secrets, right? And the thing about trade secrets is once they're gone, you can never get them back, right? And so an NDA protects trade secrets. And so the way I approach this is I say to people, look, have the conversation about the business elements first. If the business elements work and you need to get in depth into the technology or the know-how or whatever it is, then you go to an NDA. And I find that usually works better because especially, you get a feel for somebody. If you don't feel comfortable with them and then they don't want to sign an NDA, the red flag should go up, right? And usually as a general rule, if you've worked out the business issues, the disclosure of the technology or the know-how really is a formality. And I've done a pretty in-depth video on this and have a free NDA form that's available at literally freendaform.com.
Perfect. And I think we're going to attach that below the video as well, a link to that. So
Good. But absolutely. And making sure that your NDA is one that protects you, right? There's a couple of things that often come up in NDAs that I always, kind of gets me all upset is that, some of them have actually limits on the amount of time that the recipient would have to keep that information confidential. And that's kind of rough because you really don't know how long your information is going to be valuable for. And the example I give is the formula for Coke, right? I mean, that's been going on for well over a century. And so if in the early 20th century, the founders of Coke had gone out and signed an NDA and allowed anybody to use it after 7 years, we'd have lots of different variations of Coke out there.
It's a perfect example. The biggest thing is, what happens when somebody says no off the bat? Because we get that question a lot, and our answer is always no, because we see so many different things, and if somebody's asking us to sign an NDA before they even speak to us, we're not going to go down that road.
That's the key. They're asking you to sign before you even speak to them.
Right.
And so where I go with that is there nothing that you can talk about that's not confidential? Because there really has to be, not everything can be confidential, right? Right? There's got to be something about the relationship that is, generally known, right? So if I've got a new widget, I can talk about, hey, our widget is better because, without, the distinction is the what versus the how. I can talk about the what all day long, how great my widget is. It's the how that now I got to go to the NDA. That's
a perfect example. Yeah, I think that really is going to drive in, why and when you should use that document.
That's right.
One of our members asked an interesting question that I think a lot of people have. Should I form my company as a C corporation, an S corporation, an LLC, partnership, sole proprietor? There's a lot of different ways to form a company. How do you know which one to go down?
So the first question is always, are you going to have outside investors, right? And are you going to have outside investors in a short period of time, less than a year typically? If the answer to that is yes, then you're generally going to lean to forming a C corporation, because that's what intelligent third-party investors are going to want to invest in, is a C corporation. All right, so if you're not doing that, if you kind of the investor model is put in a bunch of money, grow it as fast as you can, sell it 5 to 7 years, right? So if you're not interested in that model, if you're going to go for, we're going to run this for a period of time, then you're on what we call the kind of the normal track, right? And that normal track is you're going to determine, all right, LLC or S Corp. Now, for the most part today, people are forming limited liability companies or LLCs. And that makes the most sense because they offer the best protection among the members. And then, from a tax perspective, you get to pick the various different tax options that are out there. And so LLCs are great. Now, there's a downside to LLCs, right? LLCs can be structured in any way you want them to be. But if you sign an operating agreement and haven't thoroughly read that operating agreement and don't understand it, you could have bound yourself into something you really don't want to be bound into, right? And so LLC is the way to go, but be sure you know what you're signing when it comes to the operating agreement. There is no form operating agreement.
But that's a great example. And to that point, a lot of people ask about incorporating in Delaware because, we all saw the Facebook movie, and they said, well, you got to form in Delaware. So what is that about?
So Delaware, you'll see that most public companies are in Delaware. And sometimes professional investors will want a company to be formed in Delaware. But usually what I say is start out in the state you're in. So if you're in Florida, do it in Florida. Because 2 reasons. One is it costs you extra. If you form in Delaware, you not only have to pay Delaware fees, you have to pay to have a registered agent in Delaware. And then if you take that Delaware corporation and bring it down to Florida, you have to pay a Florida fee and have a registered agent. You can do it in Florida yourself if you're located there, or whatever state, New York, that type of thing. So you're actually paying double. The other side is, for the most part, Delaware has the most expensive franchise fees of any of the states. And so not only are you paying double, but you're paying more than you need to. And if it's just what I call a closely held company, so we know the owners, there's 4, 5, 3, 2, whatever it is, partners, none of the protections of the Delaware statutes are going to apply to you because you're going to have a shareholders agreement that defines how you're going to interact with one another.
Right.
Now, the one time that you might do it is if you have a single member limited liability company, and there are some advantages, at least potential advantages, to having a Delaware LLC in that case. But for the most part, really, for everybody that's probably listening, it's going to be form an LLC in your state and use that.
So the easiest way is always the best. I know that you're a patent holder, and I'm sure you've been involved in many of these, but intellectual property is always one of those interesting subjects that a lot of people have questions around. Are there any ways that you can protect an idea without going through the patent process?
Well, so you would protect an idea as a trade secret by just literally keeping it secret, right? And so that's kind of the thing. It can't be commonly known or commonly discoverable. And then anybody who has access to the inner workings of that idea. Now, ideas are pretty broad concepts, right? And so not every single idea is going to be protectable that way, right? It's got to be something that you're using in business to gain an advantage or something along those lines. So by way of example, something that would be and should be protected as a trade secret would be your customer list, or what you pay your employees, things of this nature.
Okay, so those are really kept as a trade secret. But let's say I have a great idea for a widget. I'm going to tooling. I'm going down that path full throttle. I'm going to go for a patent. What kind of costs can I expect?
Well, it depends on the complexity of the widget that you have, right?
Okay.
So if you have a super, well, let's put it this way, an easy widget, right? Maybe 10 grand, somewhere around that range. I don't prosecute patents. So although I am a patent holder and we do licensing transactions, we don't prosecute them. But you'd be looking at 10 grand probably on on the low end, and then depending on complexity, wow, you can go quite a bit higher than that.
Okay. So if I'm trying to build the next stealth bomber, I should probably get some patents around that. That's what you're saying.
You definitely want to get patents around that.
Okay.
That's kind of a separate type of company where you go out and you build a bunch of intellectual property, and that's the value of the company. Yeah. And those guys, if you're doing that, you have to almost have an IP lawyer on staff.
Mm-hmm. And what should really be included in a contract when you bring that product? Let's say I put together my stealth bomber. I'm bringing it to market. I want to get that stealth bomber into every Walmart, every Target. I want to put it in with distributors and retailers. What should I always have included in a contract when I'm bringing something to market like that?
So usually a large distributor is going to be giving you their terms, right? Because they're giving you access to their channel. So if we look at what we're talking about, customers, if we were going to sell it direct, aside from the one that I talked about before, which is making sure that all the fights occur on our turf, right? Yeah. We want to be as specific as possible. We want to lay out what the expectations are, and frankly that applies to every contract. If you understand what the expectations are, it's a good contract, right? Okay. And so we want to talk about, hey, what are the warranty provisions, right? What do we expect this product to do and not do? Have some specifications associated with it. How is this product going to be delivered, right? So shipping, who's going to pay the shipping costs? What happens if some damage happens in shipping? Who's going to insure? And all of those types of things that go along with it. Things like payment terms. You'd be surprised how many times I see a contract that says, okay, so we're going to pay you X, whatever the dollar amount is, right? But it doesn't say when. It doesn't say what if we don't pay on time, right? That type of thing. And so getting all of that detail, and it may seem like minutia, but having that in a contract really reduces the likelihood of a dispute, because the specificity really gets people to the point where, hey, I understand what's expected of me. Now, of course, that assumes that people are honest. I can't do anything for a contract with a dishonest person, but assuming people are honest and they want to do the right thing, laying it out is perfect.
Okay, I think it's a great example, and one of the biggest things that we've seen is very much on that payment term, because the cash flow is king when it comes to small business. In knowing when you're going to get paid, how you're going to get paid is really some of the most important things that you can include in that contract. So I'm glad you touched on that. One of our members asked an interesting question. What is the biggest mistake that companies make when it comes to, company protection and the laws surrounding it? So you gave trade secrets as far as a company list and things like that. How can you protect that from employees, from people inside the company?
Well, having an employment agreement with each of your employees that recognizes, hey, there's confidential information that you're going to be exposed to, and limits their ability to disclose that, right? I mean, truly, even taking a step back, which is non-legal, it's only give people access to the things they absolutely need to know. Right? Don't leave it out there for everybody to see, because then that's a problem, right? So if your sales guys need to know their customer list for their territory, don't give them the customer list for the entire country, right? And so it's little things like that is the first step. But then having everybody sign a written agreement that protects the company by saying, these are our trade secrets, this is confidential information, you can't disclose it, you can't use it, and you can't grant anybody else access to it. Right. And laying that out, and then putting some company favorable provisions in there. So the one thing, though, I keep going back to this, but is that if you hire somebody who wants to breach those terms, you have to be ready to enforce that agreement, because if you don't enforce it against one person, everybody else in your company is going to see that. Yeah. And they're going to go, well, if you enforce it against them, they're going to go, hey, wait a second, you can't enforce it against me. You didn't enforce it against the last guy. And so you start to lose rights by doing that. So you've got to be prepared to protect that information.
What does enforcing that look like, just for my information?
You usually go to court and you get an injunction against that employee, saying where the court says to that employee, you cannot use that information, you cannot disclose that information. And then if the employee does it and you know about it, then you go back to the court and say, hey, Judge, you told Mr. Employee not to do this. He did it. I want you to hold him in contempt. And if he gets held in contempt, that means he gets thrown in jail.
Wow. Okay.
And so the point is that the court really doesn't take kindly, especially most judges don't take kindly to saying, directing somebody to do something or not do something, and then they go against that order. And so usually you get a pretty powerful response.
I think that's a perfect example of something that, the common business person never sees, but, it's a valuable tool, especially if you have something that, could potentially be a huge revenue generator, and, somebody can leave and maybe start a competitive company.
That's right.
Thank you for that insight. What would you say is the best thing that an entrepreneur can do today to really prepare their business for success this year?
It depends on the particular aspect of the business, right? Is I'm sorry about that. I got a little lost here for a second. There's so many of them. I think this is the real issue, right? Is if you look strictly from a legal perspective, it would be getting the agreements, those 4 types of agreements in place. And so if I started with one, I'd say your customer agreement, right? Because you don't want any disputes with your customers. You want to make sure that runs smoothly, because that's the cash that comes into the business. The next one I would say would be with your partners, right? Because that can be the internal process that destroys the business. From a success standpoint, outside of the law, from my standpoint, I would make sure that cash flow is there, right? You can have all the sales in the world, but if you don't collect cash, you're done.
Right.
You're out of business. So.
Okay. Well, from somebody that's seen the inside workings of, more businesses than I can imagine. Thank you so much for lending your advice and your expertise on this.
Thank you.